Welcome to this presentation on interpretation of contract by the delegation of the Republic of Ireland. The delegation will be made up of Councillor Meggie Pengili, Antici Anya Gulden, and myself, Patrick Brule, as the representative.
The outline of the presentation will be as follows. First, an introduction to the topic of interpretation of contracts will be provided. Then we will discuss the objective versus subjective interpretation. We will move on to the factors relevant for interpretation and also discuss implied terms and gap filling. Finally, we will discuss unfair contract terms and the contra proferentum rule. Then a conclusion will be given to the overall main points of the presentation. Parties often dispute as to what the context of their contract actually mean, and this may be due to, at least in part, unclear contract terms. Interpretation of the terms by both parties may differ, given the location, age, expertise, and experience of the parties in the matter. Therefore, it becomes necessary to interpret the contract in such a way as to have one single meaning, or rather one interpretation for the terms explicitly used in the contract, and the main aim is to establish the will of the parties, in line with the principles of party autonomy and contractual freedom. An interpretation of contractual terms must have the aim of establishing what the parties aimed for, and not what the courts believed to be the most fair solution. This is in line, as was previously mentioned, with the principle of party autonomy and freedom of contract. The idea behind this is to search for the common intention of the parties, which is in line with the meeting of minds principle. Now, this is achieved in two ways. First, there's a subjective interpretation, which holds that the real intention of the parties, as expressed by the terms of the contract, should be considered as the only relevant interpretation. The problem, however, is that with the actual intention of the parties, it is hard to discover what they're actually thinking and to get into the minds of the parties. On the other hand, the objective interpretation holds that the external expression of the will of the parties, meaning what the terms of the contract say, is the one to be interpreted, since these terms are the closest to discovering the true intent of the parties. Moreover, it is also what the opposing party can actually rely on, so it is only reasonable that the meaning of the declaration actually made should be used. Learned Hand in Hotchkiss versus National City Bank of New York is one of the most prominent judgments concerning the objective interpretation of contracts. These interpretations have been contested in both civil law and common law jurisdictions. In France, Article 1156 of the Civil Code sets forth that the courts must find the common intention of the parties, whereas Articles 1158 to 1160 prescribe that ambiguous terms should be interpreted according to the meaning of the contract. In Germany, paragraph 133 of the BGB holds that the aim of interpretation must be to find the real intention of the parties, and this paragraph is to be read in conjunction and in light of paragraph 157 BGB, which states that the interpretation must be fair and reasonable. In England, the traditional starting point when dealing with uncertainties in contract interpretation is to interpret the contract according to its literal meaning. The case law where this approach was adopted is Lovell and Christmas Ltd versus Wall. This approach is no longer used. Instead, in Investors' Compensation Scheme Ltd versus West Bromwich Building Society, it was held that the reasonable person standard would apply to interpretation. This standard entails that courts will interpret the contract terms in the same way a reasonable person in the same position as the parties, holding the same knowledge, would interpret the terms. In Ireland, the principles of interpretation are quite similar to those in England. In fact, in Law Society of Ireland versus Motor Insurers Bureau of Ireland, they refer to the ruling that Lord Hoffman gave in Investors' Compensation Scheme case. Essentially, in Ireland too, they use the reasonable person standard. The previous negotiations of the parties and their declarations of subjective intent are disregarded and can only be used in an action for rectification. Moreover, the case law also makes clear that the meaning of the document is not the same thing as the meaning of its words. The meaning of words is a matter of dictionaries and grammars. The meaning of the document, on the other hand, is what the parties using those words against the relevant background would reasonably have been understood to mean. The conclusion we can draw from these national approaches is that civil law jurisdictions primarily place an emphasis on the common intention of the parties, meaning that they use the subjective approach, while common law jurisdictions apply the reasonable person standard, meaning the objective approach. However, the outcome is generally the same in all of these countries because of the PECL, and that can be seen in Article 101 of Chapter 5.
There are several factors which courts take into consideration when interpreting ambiguous clauses in contracts, such as the conduct of the parties, the nature and the purpose of the contract, the knowledge and experience of the parties, the interpretation that they give to similar clauses, and also adherence to the principle of good faith. This is also reflected in Chapter 5, Article 102 of the Principles of European Contract Law, as can be seen in this picture. One of the most important of these considerations is the doctrine of good faith, so for the purposes of assessing the national approaches, we will focus on this. As a preliminary remark, it should already be noted that there is a sharp distinction when it comes to good faith between civil law jurisdictions and common law jurisdictions. Generally, the former acknowledge the existence of the principle of good faith, whereas the common law jurisdictions do not. In civil law jurisdictions, the principle refers to parties' obligations to engage in fair and open dealings with one another. It has also three main functions. Firstly, a supplementing function in the sense that it fills the gaps in contracting when the parties have not provided for a solution themselves. Secondly, it has an interpretive function whereby the courts and even the parties themselves have to interpret the terms of the contract in light of the doctrine of good faith. Finally, it has a restrictive function because it restricts party autonomy by not allowing them to escape otherwise binding contracts. This principle is enshrined in the French Code Civil in Article 1134, subsection 3, and in the German Civil Code in paragraph 242. On the other hand, in England, a common law jurisdiction, there is no such principle of good faith. Although they do, however, have certain other hurdles, such as consideration, that restrict parties in a similar fashion to the principle of good faith. The Irish system, not surprisingly, is not much different than the English one. In Flynn and Anor, the court reaffirmed that there is indeed no general doctrine of good faith in the Irish contract law. However, it also noted that certain exceptions exist, such as when the parties expressly opt into it in their contract, also where parties enter into a partnership agreement, and also with regard to suretyships. Another exception is the principle of uberrima fide in insurance contracts, whereby the policyholder has a duty of good faith to disclose all necessary information to its insurer. There are also certain equitable doctrines and concepts which correspond approximately to the civilian concept of good faith and serve a similar function, such as the doctrine of constructive notice, the principle that he or she who comes to equity must come on with clean hands, and so on. However, none of this is good faith per se. Moving on to implied terms and gap filling, it should be noted that parties in a contract have an important responsibility of communicating between one another what rights are being given and received. However, a failure to do this properly may create issues and eventually lead to a dispute between the two. Legal systems generally provide a set of general rules of contract which include standard implied terms and gap-filling terms. It is no surprise that most of disputes between parties in a contract involve questions of interpretation and implied terms, since it is impossible for express terms in a contract to cover all eventualities possible. Implied terms serve the function of covering all these eventualities. So, for instance, when parties are in a dispute with one another and they argue that express terms do not properly reflect the intention they had when they entered into the agreement, the court may step in and imply terms in order to fill the gaps of the contract. Gap filling also provides for solutions to problems created by incomplete contracts. Generally speaking, there are two ways in which this can be done. Constructive or supplementary interpretation, also known as ad hoc gap filling, is where courts construct terms that were not considered by the parties during formation, and this is a way that gap filling can be used. The other way is gap filling through default rules. These are rules which are automatically applicable to neglected parts of the contract if parties did not expressly state that they wouldn't be bound by them. Different legal systems have chosen different approaches to how they imply terms of how they fill gaps in the contracts. In some jurisdictions, the intention of the parties serves as the basis for ad hoc gap filling. This is the approach chosen in France and in Germany. France's approach to this issue is laid down in Article 1194 of the Code Civil and is referred to as interprétation créatrice. In Germany, on the other hand, when parties have omitted to lay down something in their contract, the court must discover and take into account what they would have said if they dealt with the point in question in light of the purpose of this contract. This was established in the swapping doctors case. In the English system, on the other hand, they mostly deal with implied terms, and there are four categories of these terms. Those implied by fact, by law, by custom, and finally by trade usage. There are two tests which courts have generally used to determine this intention of the parties. Firstly, there is the officious bystander test, which holds that implied terms are something so obvious that it goes without saying, so that if, while parties were making their bargain, and an officious bystanders were to suggest some express provision for it in their agreement, they would say, "Oh, of course." So it must be something extremely obvious. This was elaborated in the Sherlaw versus Southern Foundries case. Secondly, there is the business efficacy test, which originates from the Moorcock case and holds that terms are only implied if they are obvious and necessary. The Irish approach is not that different from the English one, and in fact, in the case of Flynn and Honor, where this was addressed, the court made explicit reference to the cases of Sherlaw and Moorcock to lay down the law applicable. However, it also summarized what is included in the test of implication of terms. The requirements are as follows. First, it must be reasonable and equitable for the term to be applied. Secondly, there must be a necessity for it for business efficacy, or otherwise it must be so blatantly obvious that it is required. Thirdly, the implied term must be clearly expressed. And lastly, there must be no contradictions with other contractual terms. Thus, the Irish system again is similar to the English one, but slightly different in its approach as opposed to France and the German system. Be that as it may, the results seem to be similar in the end.
On the matter of unfair contractual terms, it must first be noted that substantive unfairness of the contract, or of individual terms, in the sense of one party having greater obligations than the other party, or obligations that are more burdensome in some way, will not be a ground for invalidation of the contract or the terms. Instead, unfair contractual terms seek to disadvantage the weaker contractual party in some way. Unfair contractual terms are often used in consumer contracts through the incorporation of general terms and conditions. Through the incorporation of these general T's and C's, consumers are forced to accept the terms or not enter into the contractual relationship at all because they have no contractual bargaining power. Producers or sellers, especially big online corporations, may seek to take advantage of this by seeking to limit or even eliminate completely their contractual liability. Due to this position of weakness, jurisdictions will offer some protection and will seek to police unfair contractual terms. This can be done in several ways. In civil law jurisdictions, at least, parties must always act within the principle of good faith, and courts must interpret contractual terms in light of the principle of good faith. In addition to this, courts in nearly all jurisdictions may set aside what they deem to be disadvantageous contractual terms in order to protect weaker parties. Lastly, when it comes to unclear contractual terms, as will be elaborated upon later, the principle or the rule of contra proferentem takes effect. Here we can see an overview of the approaches that some national jurisdictions take to the matter of unfair contractual terms. In France, a committee has been established that seeks to prohibit certain contractual terms that it deems to be unfair. These terms, which are published by the committee, may then no longer be used in contracts. Additionally, because the aforementioned committee is not very active in its role and responsibility, courts in France have been granted the power of judicial review, meaning that they can look into contracts and declare terms inapplicable themselves. Courts in Germany have also been granted this power. Additionally, in Germany, there exist gray and black lists of contractual terms. Blacklisted contractual terms may not be incorporated into contractual relations under any circumstances. Gray-listed terms may be included in contracts, but courts will determine this on a case-by-case basis. England, on the other hand, has the infamous red hand rule, where courts have decided that the more onerous a clause is to the weaker party, the more attention must be drawn to it, hence red hand. Additionally, courts in England also have the power of judicial review. Finally, coming now to the national approach of Ireland, the approach of Ireland was incorporated in the Sale of Goods and Supply of Services Act 1980, which mirrors exactly the English Sale of Goods Act of 1979. Additionally, AIB versus Peter and Mary Cunningham of 2016 holds that courts, Irish national courts, must examine unfair terms under EU law. Hence, the approach of Ireland is very much the same as the approach of England, in addition to EU legislation. The EU legislation mentioned in the previous slide refers to Directive 93/13 on unfair terms in consumer contracts. The area of unfair contractual terms has therefore been harmonized to a minimum extent by EU legislation. Directive 93/13 establishes, in the German example, an EU-wide grey and black list of contractual terms. Additionally, it includes a requirement of good faith. It must be kept in mind here that this requirement of good faith now applies also to Irish and English jurisdictions. Therefore, to some extent, good faith has now been incorporated in common law, in national common law jurisdictions due to harmonizing EU legislation. The matter of contra proferentem was already mentioned previously under the matter of unfair contractual terms, specifically as a manner for jurisdictions to protect weaker parties. Indeed, contra proferentem is a so-called maxim of interpretation, meaning that it is a judicial rule instructing courts on how to handle ambiguous contractual terms. The contra proferentem rule simply states that ambiguous contractual terms are interpreted against the drafting party and in favor of the interpretation of the recipient of the draft. This grants protection to the recipient of the draft and encourages the drafter to be careful, precise, and exact in drafting the contractual terms. This rule of contra proferentem was included in EU legislation in the directive mentioned previously, Directive 93/13 on unfair terms in consumer contracts. Hence, it is now applicable throughout all EU jurisdictions. In conclusion, it can be stated that the interpretation of contracts is essential for a proper contractual functioning. The aim is to give a single meaning to all contractual terms used. Anything less would lead to legal uncertainty and the breakdown of essential contractual relationships, since it would not be clear which interpretation of contractual terms is correct and therefore applicable. On the matter of Irish law belongs to the common law family and therefore adheres very much to the precedents set by English law. This is very much reflected in the fact that Irish cases often refer to previous English judgments. Irish law therefore differs from civil law in many areas. For example, it does not include a general doctrine of good faith. Furthermore, it can be stated, as has been seen, that interpretation of contracts has been harmonized somewhat by the European Union in certain areas, especially by Directive 93/13. We thank you for your attention and hope that you have enjoyed this presentation by the delegation of the Republic of Ireland.